President Donald Trump adds to his growing list of legal troubles with a fourth indictment, this time from a Georgia grand jury. This latest indictment stems from the investigation in Georgia about Trump's attempt to overturn the 2020 presidential election. Thanks for joining us for this special edition of In the News Now. I'm Stephanie Haney. First, allegations of falsifying business records tied to hush money payments to a former adult film star. Then, hoarding classified records and impeding efforts to return them, followed by efforts to overturn the 2020 election at the federal level that led to the January 6 riots, and now interfering with the presidential election at the state level in Georgia. Here's what we know about these latest criminal charges against the former president.
Fulton County District Attorney Fani Willis opened the investigation in early 2021. That was shortly after a recording of a phone call between then President Donald Trump and Georgia Secretary of State Brad Raffensperger was made public. During that phone call, which took place in early January 2021, Trump repeatedly insisted that he had won Georgia in the 2020 presidential election, and he suggested that Raffensperger could help him find the votes needed to overturn his narrow loss in the state.
Look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have.
Over the last 2 years, it has become clear that Willis is interested in far more than just that phone call between Brad Raffensperger and Donald Trump. When she began the investigation, she said in a letter to top state officials that she was looking at potential violations of the law, including solicitation of election fraud, making of false statements, conspiracy, racketeering, and violation of oath of office. And she's been very interested in a panel or a slate of 16 Republican fake electors. These are people who signed a certificate falsely stating that Donald Trump had won Georgia and that they were the duly elected and qualified electors for the state. Willis took the unusual step of requesting a special grand jury. A special grand jury has the power to subpoena documents and witnesses, but it cannot issue indictments. It's really more of an investigative tool. The special grand jury was seated in May of last year, and between June and December, they heard from about 75 witnesses. That included some really high-profile Trump associates like Rudy Giuliani, U.S. Senator Lindsey Graham, former White House Chief of Staff Mark Meadows, and they also heard from some top state officials like Georgia Governor Brian Kemp, Secretary of State Brad Raffensperger, and Attorney General Chris Carr. Trump himself was not asked to come testify, and he did not appear before the special grand jury.
Trump has been in and out of court this year while campaigning for the Republican ticket in the 2024 presidential race. His third indictment came August 1st, stemming from the January 6th deadly attack on the U.S. Capitol in 2021. Special counsel Jack Smith announced the indictment, accusing Trump of conspiring to defraud the United States, conspiring to disenfranchise voters, and conspiring and attempting to obstruct an official proceeding.
The attack on our nation's capital on January 6, 2021, was an unprecedented assault on the seat of American democracy. As described in the indictment, it was fueled by lies. Lies by the defendant targeted at obstructing a bedrock function of the U.S. government, the nation's process of collecting, counting, and certifying the results of the presidential election. The men and women of law enforcement who defended the U.S. Capitol on January 6th are heroes. They are patriots, and they are the very best of us. They did not just defend a building or the people sheltering in it. They put their lives on the line to defend who we are as a country and as a people. They defended the very institutions and principles that define the United States. In this case, my office will seek a speedy trial so that our evidence can be tested in court and judged by a jury of citizens. In the meantime, I must emphasize that the indictment is only an allegation and that the defendant must be presumed innocent until proven guilty beyond a reasonable doubt in a court of law.
Before that, Trump pleaded not guilty in June to 37 federal felony counts accusing him of illegally hoarding classified records at his Florida estate and rejecting government demands to give them back. Later, 2 more charges were added, alleging 2 obstruction counts based on allegations that Trump and others attempted to delete surveillance video footage at Mar-a-Lago in the summer of 2022. A judge in that case heard arguments over whether that trial, which would take place in Florida, should happen before or after the 2024 election. Prosecutors want a December trial date, and Trump's lawyers have pushed for an indefinite delay, arguing he can't get a fair trial while he's campaigning for president. Eric Tucker with the Associated Press goes inside the classified documents case.
January 2021, as Donald Trump was leaving the White House, boxes of thousands of government records, including what we now know to be hundreds of classified documents, were packed in boxes and taken to Donald Trump's Florida home, Mar-a-Lago. And it became clear to the National Archives and Records Administration that it was missing a variety of documents that it believed it was entitled to have back because they were government records. And that began a months-long negotiation process by the government to obtain the documents. The investigation really takes a very dramatic turn in January of 2022 when the National Archives receives from Mar-a-Lago 15 boxes of records, and when it opens those records, it discovers more than 100 bearing classified markings. At that point, it alerts the Justice Department to the disclosure and discovery of classified records. The Justice Department at that point becomes involved, and months later, it issues a subpoena to the Trump orbit, seeking the return of any and all classified documents that remain in his possession. And this is, again, where the investigation truly escalates, because the Justice Department goes to Mar-a-Lago to collect what it believes to be the entirety of the classified records. It receives roughly 3 dozen. And it obtains information leading investigators to believe that there are yet many more that still remain. In August, specifically August 8th, 2022, the FBI searches Mar-a-Lago armed with a search warrant, and at that point retrieves roughly 100 documents bearing classified markings. And in addition, the assertion, which wound up being false, that all of the documents in Donald Trump's possession had in fact been returned, that wound up not being the case, and the Justice Department came to believe that it might have evidence of potential obstruction, which is in and of itself a crime too. So the mishandling, or what we call the willful retention of national defense information, and obstruction are felonies that carry, years in prison. But this is a federal case, and that infuses it with a degree of gravity that is notable. Although prosecutions of defendants for mishandling classified documents are routine, there is nothing routine about this particular investigation. The politics of it are truly extraordinary and unprecedented. In addition to this being the first federal case against a former president, this is also the first federal case against a leading presidential candidate.
Supporters of Trump have called this investigation politically motivated. Now, in emotionally charged situations like these, special counsels are appointed to look into cases. This happens when the Justice Department perceives itself as possibly having a conflict, or where it's deemed to be in the public interest to have someone outside the government come in and take responsibility for an issue. The man behind the months-long investigation into this classified documents case, that man is Special Counsel Jack Smith. Last year, U.S. Attorney General Merrick Garland picked Smith, a veteran war crimes prosecutor with a background in public corruption investigations, to lead this one. The Justice Department has said Trump repeatedly resisted efforts by the National Archives and Records Administration to get the documents that are at issue in this case back. A search of his Florida estate turned up 33 boxes. Those boxes contained classified records, including top-secret documents stashed in a storage room. Our colleagues at WWL in New Orleans take a look at what the Presidential Records Act has to say about who owns these kinds of documents and how they have to be handled.
The National Archives and Records Administration is the nation's record keeper. It manages everything from the original U.S. Constitution to military records to a huge online research database about ancestry and U.S. history. It's also in charge of the official record of the president. The Presidential Records Act of 1978, which followed President Richard Nixon's resignation, requires presidents and vice presidents to file away memos, letters, notes, emails, faxes, phone records, texts, and other written communications. A 2019 report by the Congressional Research Service details the process. The administration is by law required to turn the files over to the Archivist of the United States when they leave the White House. The archivist's job is to process and manage those documents. Between 5 and 12 years after a president's term, some classified documents are restricted, but otherwise everything's available to the public. And after 12 years, almost everything is public record unless a president is granted a claim of executive privilege. In January, archivists suspected Trump had violated the Presidential Records Act. Soon after, the Department of Justice recovered 15 boxes of materials from Mar-a-Lago that Trump should have turned over, some containing classified information. In this most recent search of Mar-a-Lago, the FBI was likely searching for more documents Trump didn't turn over. If Trump is found to have violated the Presidential Records Act, he'd be the first former president to do so. And there are penalties he could face for destroying White House records, penalties that Trump himself signed into law as felonies while he was in office.
These charges out of Georgia make up Trump's fourth indictment this year. The first indictment came in March when he was criminally charged with 34 counts of falsifying records and bribing adult film star Stormy Daniels with hush money. Trump has pleaded not guilty to those charges. We take a look back now at key moments from when those initial 34 charges came out.
This was an extraordinary day. Lots of security, lots of logistical concerns, bringing Donald Trump to a courthouse to address these charges. He was in court for about an hour. He sat there, most of the time not saying a word, letting his lawyers and prosecutors do the talking. But when he was asked how he pleaded to these charges, he firmly said not guilty. And in perhaps the most dramatic moment of the entire proceeding, at least from Trump, as he was leaving court, he turned to the prosecutor who revived this case and brought these charges, Alvin Bragg, Manhattan District Attorney, and he glared at him for several seconds before turning back to the aisle and walking out of the courtroom. Now, there were some other key moments at this proceeding today. Donald Trump was admonished for his social media posts attacking the grand jury process, attacking the integrity of this case, and making comments with heated rhetoric about the prosecutor Alvin Bragg, about witnesses including Michael Cohen and Stormy Daniels, the porn actor that alleges an extramarital sexual encounter and who received that hush money payment. He was admonished to refrain from that rhetoric. The judge didn't go so far as to issue a gag order, and prosecutors didn't ask for one, but the judge did ask the defense to urge Donald Trump to refrain from any comments that could incite violence or civil unrest. And he's not due back in court until December 4th. Defense attorneys asked to have him skip that next court appearance. They asked that he not have to attend because of the extraordinary circumstances this time in bringing Donald Trump to court. They cited the security, the expense, the logistics that went into it. But Judge Juan Merchan, who's presiding over this case, he said he was not inclined to give Trump a pass out of his next court appearance.
Former President Trump faces 34 charges of falsifying business records in the first degree. We're looking into what that charge means in your breakdown. Here's the part of New York State Code which defines falsifying business records in the first degree a Class E felony. The New York court system says this could include removing, creating, or omitting a business record with the intent of covering up another crime. To be found guilty, New York law states that prosecutors must prove two things. One, that there was falsification of business records, and two, that there was intent to defraud or commit or conceal another crime. The intent to conceal another crime is what makes this a felony charge. That's why this statement of facts in Trump's case doesn't just include the list of charges and alleged false business entries, but also a narrative of the 11 hush money payments the district attorney says he intended to cover up. Prosecutors say Trump orchestrated an unlawful scheme to influence the 2016 election by paying off people and suppressing negative stories about him. The complaint says he, quote, violated election laws and made and caused false entries in the business records of various entities in New York. The DA did not have to name what specific crimes Trump may have been trying to cover up, but it's likely a combination of state and federal election, campaign, and tax violations. And remember, that's important. Going back to our original New York code, for a jury to find Trump guilty of felony falsifying business records, prosecutors will have to prove 1, that Trump did change the ledgers on his business records, and 2, that he did so in order to cover up an illegal scheme meant to influence the 2016 election.
Falsifying records to influence a presidential election is a big deal.
Legal analyst Dan Eaton says if the allegations against Donald Trump are true, they're very serious. But he also warns that it's a long road from grand jury indictment to unanimous guilty verdict by a jury. And Trump's attorneys say they plan to fight the charges.
He's frustrated, he's upset, but I'll tell you what, he's motivated, and it's not going to stop him, and it's not going to slow him down.
According to court documents, the former president said money was used to pay legal fees when it really went to a porn star for hush money so she wouldn't expose his infidelity right before the 2016 election.
The defendant repeatedly made false statements on New York business records. These are felony crimes in New York State, no matter who you are.
That said, Eaton doubts if convicted, Trump would spend any time in prison.
It's very, very unlikely based on the nature of these charges. And the reason it's unlikely President Trump is looking at jail time is because he's going to be a first-time offender.
Which makes some people question if these charges are even worth the effort, especially since the former president is facing multiple federal investigations surrounding his handling of classified material and what happened January 6th at the Capitol. But Eaton doesn't see it as an either-or situation.
No person is above the law.
Earlier this afternoon, Donald Trump was arraigned on a New York Supreme Court indictment returned by a Manhattan grand jury on 34 felony counts of falsifying business records in the first degree. Under New York state law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct. The defendant repeatedly made false statements on New York business records. He also caused others to make false statements. The defendant claimed that he was paying Michael Cohen for legal services performed in 2017. This simply was not true. And it was a false statement that the defendant made month after month in 2017. April, May, June, and so on through the rest of the year. For 9 straight months, the defendant held documents in his hand containing this key lie, that he was paying Michael Cohen for legal services performed in 2017. And he personally signed checks for payments to Michael Cohen for each of these 9 months. In total, the grand jury found there were 34 documents with this critical false statement. Why did Donald Trump repeatedly make these false statements? The evidence will show that he did so to cover up crimes relating to the 2016 election. Donald Trump, executives at the publishing company American Media Incorporated, Mr. Cohen, and others agreed in 2015 to a catch and kill scheme. That is, a scheme to buy and suppress negative information to help Mr. Trump's chance of winning the election. Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The participant scheme was illegal. The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap. And the false statements in AMI books violated New York law. That is why Mr. Trump made false statements about his payments to Mr. Cohen. He cannot simply say that the payments were a reimbursement for Mr. Cohen's payments to Stormy Daniels. To do so, to make that true statement, would have been to admit a crime. So instead, Mr. Trump said that he was paying Mr. Cohen for fictitious legal services in 2017 to cover up actual crime committed the prior year. The conduct I just described and that which was charged by the grand jury is felony criminal conduct in New York State. True and accurate business records are important everywhere, to be sure. They are all the more important in Manhattan, the financial center of the world. That is why we have a history in the Manhattan DA's office of vigorously enforcing white-collar crime.
The charges are related in part to hush money payments made during the 2016 presidential campaign. Trump pleaded not guilty to all counts. Several Verify viewers have asked us if it's actually legal to make hush money payments. So let's verify. Our sources are Paul Schiff Berman, a law professor at the George Washington University, and court records in the criminal case against Michael Cohen, Trump's former personal attorney. This claim needs context. Let me explain. Hush money is exactly what it sounds like. Someone is paid money to keep a secret. That could be for things that are legal but embarrassing, like an affair. Hush money can also be included as part of a legal non-disclosure or confidentiality agreement, commonly known as an NDA. While there are no laws that explicitly prohibit paying somebody money to keep a secret, according to law professor Paul Schiff Berman, there are some cases when hush money payments can be connected to illegal activity, like in the case of blackmail or extortion. Doctoring financial records or disguising hush money payments as something else could also be considered illegal. So, how does this apply to former President Trump's indictment? The former president isn't actually being charged for making a hush money payment. He's facing charges for allegedly attempting to cover it up. With your Verify, I'm Ariande Till.
As we've said, the former president is running for the presidency again. He is the GOP frontrunner right now, and this begs the question, if he wins the White House, could he pardon himself for these crimes? Our National Verify team takes a look at the question, focusing on the first 3 indictments, which include federal and New York State charges.
On August 3rd, former President Donald Trump pleaded not guilty in his 3rd criminal indictment, his 2nd in federal court. The first was in New York State court. Several Verify viewers reached out to ask if Trump could possibly pardon himself if he's reelected as president. So, let's verify. Could Trump pardon himself for any federal or state convictions if he's reelected as president? Our sources are the U.S. Constitution, a ruling by the Supreme Court, the Department of Justice, the Brennan Center for Justice, and 3 constitutional law experts. For the federal charges, the answer is maybe, because there is no clearly stated law or legal precedent, meaning this hasn't happened before. The Constitution gives the president broad power to issue pardons for federal crimes. The only explicit restriction that the Founding Fathers included was that a president cannot pardon themselves in cases of impeachment.
I don't think that they have ever considered or imagined a situation where the president would need to pardon himself. But here we are.
The closest we've come was in 1974, just days before President Richard Nixon resigned. The DOJ issued a memo that said, under the fundamental rule that no one may be a judge in his own case, the president cannot pardon himself. However, that opinion was never tested in court because Nixon resigned.
The question is it enforceable? And the courts would have to decide that. And ultimately, that case is going to wind its way to the United States Supreme Court. Former President Trump would probably be in pretty good standing with the United States Supreme Court.
As for Trump's indictment in New York on state criminal charges, all of our sources agree that no, Trump cannot pardon himself in that case because the Constitution only gives him the power to issue pardons for federal crimes. New York's Constitution says that only the governor can grant pardons or clemency to people, and only after they're convicted. With your Verify, I'm Brandon Lewis.
As for Georgia, Trump would not be able to pardon himself. That's because in Georgia, the authority to grant pardons belongs to an independent state board. Trump has denied wrongdoing in all of the criminal trials he faces and dismisses these prosecutions as an effort to hurt his 2024 campaign. We'll keep you updated as these cases move forward. Thank you, as always, for being with us for this edition of In the News Now. I'm Stephanie Haney.